Good afternoon, everybody, and welcome to Phil Fisher's session this afternoon on navigating the AdTech ecosystem. My name is Leonie Power. I am a partner in the Privacy, Security and Information Law team here at Phil Fisher in London. I am joined today by my colleagues Kirsten Whitfield, a director in the same team, and by my colleague Camille Ebden, a senior associate in the same team. Today we're going to cover a number of different areas that we think are relevant at the moment or trending at the moment in the AdTech ecosystem. Before we launch into the agenda, just a couple of housekeeping issues. If there are any questions as we go along, please feel free to put them into the questions box. We will deal with all questions at the end. To the extent that we don't have time to do so, we will ensure that we follow up with answers to those questions after the event. We will also be sending out copies of slides to everybody who has registered for the event. So without further ado, in terms of what we're going to cover today, we're going to look at the implications of the Belgian DPA decision in relation to the IAB Europe's transparency and consent framework. So Camille is going to cover various points on that theme. Then Kirsten's going to take a look at the implications of the DPA decisions in relation to Google Analytics. And finally, I'll say a few brief words on the pivot towards using first-party IDs and the data protection issues that arise in that context. And then hopefully we'll have some time for Q&A at the end. So on that note, I will hand over now to Camille, who will talk to you about the implications of the Belgian DPA's decision in relation to the IAB's Europe's transparency and consent framework.
Great, thank you very much, Leonie, and good afternoon, everyone. So if we move on to the first slide then, please. So before we dive into the Belgian DPA's decision on the TCF, we thought it would be helpful to have a recap on the AdTech ecosystem and the AdTech challenges that the TCF was designed to help overcome. So AdTech is, of course, essentially about connecting publishers, i.e. website or app operators, who have advertising spots available with advertisers who want to buy that ad inventory so that their ads will be displayed to individuals visiting those publisher sites. However, the ecosystem has become a bit more complicated than just having those two types of parties directly dealing with each other. You'll see on this diagram next to the publishers, we have the supply side platforms, SSPs, and they essentially allow the publisher to connect advertising inventory to multiple ad exchanges. And they're also essentially a piece of software allowing the selling of ads in an automated fashion. So when an advertising opportunity arises because a user has visited a particular publisher website, then a bid request is issued. And this contains information about the advertising opportunity, including some kind of device identifier. That then goes to the ad exchange, you can see in the middle there. And they're essentially a digital marketplace. So they enable advertisers and publishers to buy and sell advertising space. And then on the other side of the ad exchanges, we have the DSPs, the demand side platforms. And they aggregate demand from a variety of sources, including ad networks. And they're essentially a piece of software that allows ads to be bought in automated ways. They also help advertisers to decide which ad impressions, i.e. ad opportunities, to purchase and how much to bid. And they do this based on information from the cookies tracking a user, which gives them information about the user's likely interest, for example. And that enables the DSPs in turn to determine the value of an ad impression for a particular advertiser and decide what price to bid. The highest bidder wins and the ad is served. And with real-time bidding, or RTB, This buying and selling of advertising inventory is automated and it takes place in real time. So essentially the time it takes for a web page to load in a user's browser. However, we will see on the next slide that this complicated web of parties, when overlaid on compliance requirements, has led to several challenges for the ad tech industry. So let's take a look at the ad tech compliance problem. So there are various rules that ad tech participants are going to be subject to. By way of a very quick recap, firstly, if we look at the e-privacy rules, there's a transparency requirement and a consent requirement. If a party is accessing or storing information on a user's device, then you need to provide certain information about this to users. And additionally, the user's consent will be needed before any such access or storage, unless it's strictly necessary for the service requested by the user, or it's needed for the sole purpose of facilitating the transmission of a communication over an electronic communications network. Now, the e-privacy rules come from the e-privacy directive, which had to be implemented by member states' own laws. So there are local variations in the specifics of what's considered strictly necessary, for example. And then, of course, we have the GDPR. So to the extent that a party in the chain is processing information that is personal data, which in the ad tech context is very likely, seeing as ad tech is all about being able to single out individual users, even if you don't actually know fully who that person is, well, then you again are going to have a transparency obligation. GDPR requires that transparency information is provided to users. Particular information has to be provided to them, and we tend to see this in privacy notices. And then also the party will need a valid legal basis. In the context of ad tech, in practice, this is either going to be consent or potentially legitimate interests, but we will have more on that from the TCF decision later. Now, this is problematic, or these obligations are problematic in the ad tech ecosystem because usually it's only the publishers who have the direct relationship with the users. So other parties in the chain need to rely on the publisher to facilitate the transparency to users and to either obtain a valid consent for the ad tech party in question or provide an opt-out if legitimate interests is being relied upon. And given the large numbers of players in the ad tech chain, it's no mean feat for publishers to provide the relevant transparency and to have consent and an opt-out system that meets all the requirements of GDPR, e-privacy, local law, case law, and the regulatory guidance. Parties in ad tech chains often process personal data for similar purposes, but these can end up being described inconsistently. And consents can also greatly vary in terms of how granular they are and the extent to which they meet the requirements of the relevant laws and guidance. Now, we have had consent management platforms, CMPs. They started popping up to help publishers, but there was still a lack of consistency in language and compliance levels. So if we move over to the next slide, we're going to take a look at how the TCF is intended to help. So IAB Europe, the International Advertising Bureau Europe, came up with a suggested solution, which was the Transparency and Consent Framework, known as TCF. The aim is to help all parties in the ad tech chain comply with GDPR and the e-privacy directive, particularly by providing a common language for disclosing vendors, purposes, and legal bases, and communicating user consents or opt-outs between the parties in the chain. And TCF version 1.1 was launched back in 2018. And then in August 2019, after further consultation and discussions with regulators, as well as the industry, a new version was launched, TCF version 2, and that's the version we have now. But what actually is the TCF? Well, it's a framework and a set of policies for publishers, consent management platforms, i.e. CMPs, and vendors. Now, CMPs do what they say on the tin. They provide a platform to manage transparency and consent. And this will involve a user interface that users will see then when they visit a particular site. And you can see that we have on the slide an example of a TCF CMP. Now it's got a tab listing the purposes over on the left. It's got a tab listing the vendors over on the sort of towards the top right. And it's also got tabs that enable you to see which vendors are relying on consent and which are relying on legitimate interests per purpose. And on the various tabs, there are on and off buttons that enable a user to consent or object purpose by purpose or vendor by vendor. Now, I've been speaking about vendors. Vendors in the TCF world are essentially all the other parties that are part of the delivery chain of digital advertising to the end user. So they're principally the SSPs, the ad exchanges, and the DSPs. Now, importantly, with the TCF, they've come up with a set list of 12 purposes, and CMPs have to describe these purposes using certain standard, or at least certain standard language. There's a registration process with certain criteria to become a TCF registered vendor or TCF registered CMP. And there's also a list of vendors, or known as the global vendor list, which sets out for each registered vendor which of the standard purposes they intend to process personal data for, the legal basis that they seek to rely on for those purposes, and a link to their privacy policy. And then that information is what the CMP draws on to then present in this user interface. And then lastly, the other key point about the TCF is that it provides a set of technical standards regarding, for example, how a user's choices are captured, how they're stored, how they're retrieved, and how that information is shared through the ecosystem to the vendors. So if we move to the next slide, please. So this brings us to the 2nd of February this year, when the Belgian Data Protection Authority, the APD, issued an administrative ruling against IAB Europe. And they set out areas where they think the TCF in its current form does not provide GDPR and e-privacy compliance. And I'm going to discuss these views in more detail shortly. But firstly, what's happened since, and what has IAB Europe actually been ordered to do? Well, they were ordered to prepare and submit a remedial action plan of how they will resolve the areas of alleged non-compliance by the 2nd of April. And they were told that if and when the action plan is agreed by the Belgian DPA, IAB Europe would have 6 months to implement the suggested changes in that plan. However, as you'll see from the slide, on the 4th of March, IAB Europe announced that they had filed an appeal to the Belgian Market Court against the Belgian DPA's decision. And I'll also be providing a bit more detail on this on the next slide. So IAB Europe also asked for enforcement of the decision, including the requirement to produce a remedial action plan, to be suspended until this appeal completed. But a decision on whether to grant this request has not yet been issued, and IAB in the meantime have therefore already submitted an action plan on the 1st of April in order to meet that 2nd of April deadline. And this action plan has not been made public. A key question we've been asked by lots of our clients is how long is the appeal on the substantive issues going to take? And the answer is, well, it's unclear, but we understand from our colleagues in our Belgian office that turnaround times of 6 months are not unusual for appeals on the merits of a case in the Belgian Market Court. But given the complexity of the issues at stake here, we think there are good reasons to think that an appeal may take longer in this instance. So we'll have to watch this space. If IAB Europe's substantive appeal fails, then if and when the action plan is agreed by the Belgian DPA, as mentioned, they will have 6 months to implement the agreed action plan, which we expect would be by way of a TCF version 3. So let's move on now to the next slide, please. And we're going to take a look at what the Belgian DPA, the APD, said in their decision and what IAB Europe have said on those particular issues. The APD's views are essentially in two parts. Firstly, they set out views as to IAB Europe's own status and compliance regarding the TCF. And secondly, they set out views on whether TCF in its current form enables sufficient GDPR and e-privacy compliance for TCF participants. Now, today I'm going to focus on the latter, as it's probably of more relevance to more people. And we've broken the APD's views on the TCF into four key topic areas: transparency, consent, and legitimate interests in the TCF, and the view that IAB Europe has a joint controller role with other TCF participants. Now, it's worth noting at the outset that IAB Europe have highlighted that they have grave reservations on the substance of the decision, and they've submitted an appeal. But they've also said that they feel the ruling makes clear that what the APD wants is actually more TCF, not less. And IAB Europe have set out a strong message that TCF can and will continue to improve in ways that better align with the APD's vision and other DPA guidance. Okay, so moving to the first of our key topics from the decision, transparency. In the APD's view, the current form of the TCF does not provide sufficient transparency to data subjects. In particular, they said that they felt that the TCF processing purposes are expressed in too generic a manner and were not specific enough. So these are the 12 set processing purposes that they're talking about there. They also felt that the large number of vendors involved meant that transparency could not effectively be given, even though these vendors are listed. In their view, it's just not possible when there are so many for data subjects to really be aware of all of them. They also felt that the user interface does not clearly and simply enough identify which AdTech vendors will process a data subject's data for a specific purpose. So what have IAB Europe said regarding the transparency provided via TCF? Well, they've emphasised in their public FAQ document about the decision that TCF is a minimum standard on how publishers can document the relevant transparency information. And they've set out that whilst the appeal is ongoing, TCF participants could consider additional information disclosures if they wanted to. IAB Europe have also raised the point that they have already made changes to the purposes in the second version of the TCF, and that was following contact with several supervisory authorities. So they seem to be highlighting here that they're willing to keep working, it would seem, with supervisory authorities, and they have indeed already done so. And this seems to come down to the age-old transparency issue of needing to balance granularity with the need to also keep wording concise and user-friendly. So it'll be interesting to see where this ends up in the appeal. But moving on to the second key issue from the decision, consent. In the APD's view, the current form of the TCF does not enable valid consent to be obtained from data subjects for AdTech purposes by the various vendors. Now, they said that they felt the descriptions of the TCF standard purposes are not specific enough. They concluded that TCF consents are therefore not specific and sufficiently informed, and therefore don't meet the standard to be valid consent under the GDPR. And again, they highlighted that as there are so many recipients for whom consent is obtained, the vendors, users would need a disproportionate amount of time to read this information. So in their view, consent can rarely be considered sufficiently informed. They also set out that they consider that consent cannot be withdrawn by users as easily as it was given via the TCF. And under GDPR, consent does have to be as easy to withdraw as it is to provide. They said that AdTech vendors are required to comply with a user's consent signals in real time, yet the withdrawal of consent is never immediate, according to the APD, and therefore can't be considered effective. Now, IAB Europe haven't said too much specifically on these consent points, but they have reported that the matters that they have appealed from the decision include the conclusion that the current TCF cannot be used to establish a lawful basis for processing. So moving on to legitimate interests, the APD said that the current TCF doesn't sufficiently enable legitimate interests to be relied upon by participants. In their view, there isn't enough information about specifically what legitimate interests vendors are relying on. They also felt that there's an absence of measures to adequately demonstrate that no inappropriate personal data are being shared for the legitimate interest relied upon. And again, a point that's come up a few times, due to the large number of TCF vendors that might receive data subjects' personal data, they don't feel that data subjects can reasonably expect the processing associated with this disclosure, and therefore the balancing test requirements for legitimate interests are not met. So what have IAB Europe said about legitimate interests? Well, they've mentioned publicly that whilst the formal order contained in the ruling suggests that legitimate interests should not be available for any of the TCF purposes, wording elsewhere in the decision suggests that the APD may actually only aim to ban it for profiling. So I think it's going to be very interesting to see, again, where this issue lands in the appeal and any potential changes to the TCF as a result. And this, of course, has wider implications for those relying on legitimate interests for profiling and other AdTech purposes. So lastly, a key takeaway from the decision was on joint controllership. The APD set out that in their view, IAB Europe is a joint controller with CMPs, publishers and vendors for the collection and sharing of the personal data in TC strings. And TC strings are the digital signals created by CMPs that capture data subjects' choices. Also, in the APD's view, IAB Europe is a joint controller with the same parties for the subsequent processing of the personal data by these parties. Now, IAB Europe has set out that they dispute that they have this joint controller role, and it's actually a key aspect of what they've said their appeal focuses on. Again, it will be very interesting to see where this ends up. As if this is upheld in the appeal, it's clearly going to have a knock-on result for other TCF participants, publishers, CMPs and vendors who might not currently consider themselves joint controllers and might not be compliant with Article 26 of the GDPR that sets out certain requirements for joint controllers. So we've discussed 4 key views from the decision. And if we move to the next slide, we're going to look at where does this leave us going forward, both for TCF users and the broader AdTech industry. So we can only speculate what exactly this is going to mean for the TCF and broader use of AdTech. However, it seems likely that this decision is going to have certain short, medium and long-term effects. So in the short term, for many CMPs, vendors and publishers, so far there just isn't enough legal certainty to make any changes to their use of the TCF. And so many are following a wait and see approach for now, at least until the result of the appeal is announced. And as mentioned, this could perhaps take 6 months or longer. Many publishers are, of course, dependent on advertising and ad tech to monetize the content they make available to their visitors. And so they don't feel that they can remove targeted advertising from their sites overnight without other monetization streams in place first. And also, despite the Belgian DPA's views on the TCF, it's worth bearing in mind that there aren't really any other industry standard solutions that provide a consistent transparency and consent experience in the way the TCF does. So it's felt by many in the industry that ad hoc solutions would be a more confusing experience for data subjects and are even less likely to provide valid transparency and obtain valid consent. That said, some publishers and CMPs may start to explore how they might provide additional information disclosures within their cookie banners in light of the Belgian DPA's comments. And some AdTech vendors may start revisiting their reliance on legitimate interests as a legal ground to process data for AdTech purposes. Perhaps they'll consider switching over to consent-based processing only, or at least for profiling and higher risk AdTech purposes. So what about the medium term? Well, if the appeal is unsuccessful, IAB Europe will aim to agree the action plan with the Belgian DPA. And if they do that, as mentioned earlier, they'd have 6 months to implement that action plan. And this would likely result in a new version of the TCF, i.e. TCF version 3. And as touched on earlier, IAB Europe appears optimistic in this respect, stating that TCF can and will continue to improve in ways that better align with the Belgian DPA's vision and other DPA guidance. They've also set out that it's long been their ambition for the TCF to actually one day become a code of conduct. So I think we can see a strong message from IAB Europe that this is not game over for the TCF. If, however, IAB Europe are unable to agree amendments to the TCF that satisfy the Belgian DPA, so if they don't reach agreement on the remedial action plan, then the industry are going to need to consider other ways to A, provide transparency and get consent regarding AdTech cookie use, and that would likely lead to a rise in the use of ad hoc transparency and consent mechanisms, or B, to avoid user profiling, for example, by moving to contextual ads. However, it's worth bearing in mind that contextual ads still commonly involve the use of cookies for frequency capping, for example, or anti-fraud, and therefore similar issues regarding transparency and legal basis will still be at play. So what about the long term? Well, regulatory and activist concerns about personalized advertising are unlikely to go away. And as a result, pressure on personalized advertising, we think, is likely to continue increasing with time, regardless of the outcome of the IAB's appeal. In light of this, it seems that demand will continue to grow for solutions deemed less risky, but these alternatives so far rarely seem to completely avoid the pitfalls. But it's clear that there's going to be plenty to watch in this space. So I think, first of all, we'll have to watch and see what happens with the appeal. And then I think there'll be quite a journey one way or another for the ad tech industry. And on that note, I will hand over to Kirsten, who's going to be discussing Google Analytics.
Thank you, Camille. Right. If we move on to the next slide. Now, just a very quick recap, because I'm sure many of you will have heard all about Schrems 2, and it's probably making your life very difficult, and has been since we had the Schrems decision back in July 2020. So under that decision, the court decided that Privacy Shield should be invalidated, but at the same time, they also decided that although you could use standard contractual clauses, they on their own might not be enough for your transfers to what are considered inadequate countries. So there was that decision, and very shortly after that decision, which had been instigated by Max Schrems and others in his organization NOYB, which stands for None of Your Business, sprang back into action, and they issued 101 complaints. And these were sent to various data protection regulators complaining about the use of Google Analytics and Facebook Connect, and specifically the transfer of data outside of Europe. And so this then has sat with various data protection regulators, and one of the first of the regulators to come out with a decision was the Austrian Data Protection Authority. If we move on to the next slide. So what came out of the Austrian Data Protection Authority's judgment? Now this is quite recent, this was January this year. And the Austrian Data Protection Authority said, first off, well, let's have a look at, is personal data actually being transferred? And because IP address was involved, as well as other identifiers, such as browser parameters, they came to the conclusion that yes, there was personal data involved. And in fact, in this particular case that they looked at, which they were looking at a website called NetDoctor, this particular organization had not switched on the IP anonymization feature, so that in this case there was a bit extra, so more data being transferred. So they said, okay, well, the next question is data actually being transferred to the US? So that's a factual question which they looked into, and they came to the conclusion that yes, it was. It was going to Google in the US. So there was actually a transfer of personal data taking place here. Now, at the time of the complaints, Google will have been using the old EU standard contractual clauses. So that's the version of the standard contractual clauses that the data protection regulator will have looked at. So they'll have looked at, you know, have Google put in place enough with the EU standard contractual clauses for these transfers? Well, of course, around that time, we'd also had the European Data Protection Board guidance come out, which had said, actually, these are the additional supplemental measures on top of standard contractual clauses that we'll be expecting you to have in place. So they looked at that guidance. It was the draft guidance, though, and they were actually a bit stricter in the draft guidance than they were in the final guidance. But based on the standard contractual clauses they looked at and the draft guidance, the DPA came to the conclusion that actually they didn't think that there was adequate protection in place for the transfers to the US. And not only that, but they thought that this was all highly relevant, and Google did need additional supplementary measures and security measures on the basis that Google actually would be caught by surveillance laws, FISA, and Google also reported that they regularly receive requests to access data from government authorities. So in terms of the supplemental measures that felt were needed, they looked at what Google already had in place in terms of security. And Google had encryption in place. Now, encryption is probably, I'd say, top trumps in terms of the supplemental measures in the European Data Protection Board guidance. But in this case, the Data Protection Authority came to the conclusion that that encryption that they had in place wasn't sufficient. Now, this will be because the standards set by the European Data Protection Board in their guidance are actually really, really high. They set the bar, you know, very, very high. Not only do you have to have encryption, it has to be encryption of a certain standard. Other criteria apply as well. For example, the encryption keys need to be held in Europe. So it's very, very difficult to comply with. And in this case, when they looked at it, they came to the conclusion that these standards were not being met. So they concluded, actually, data is being transferred outside of Europe to a country that we consider inadequate, and we think supplemental measures need to be in place, and those that are in place at the moment are not adequate. So ultimately, this was a transfer of personal data outside of Europe in breach of the GDPR. And also interestingly, in this particular case, they said, it's not actually Google that has to comply here, it's the data exporter's responsibility, and that was NetDoctor. So it was NetDoctor that was in violation of the GDPR laws. They didn't look at consent or contractual necessity, which are other ways in which you can potentially transfer personal data outside of Europe, because that wasn't being done here, so they didn't look at that in this particular judgment. So if we move on to the next slide, please, Leonie. So the Austrian DPA, they were just the first of what seems to be an avalanche of either decisions or opinions that have now started coming out since the January decision from Austria. So just to give you a heads up or overview of what we've been seeing from other regulators around the use of Google Analytics. So on the 10th of February, the CNIL, which is the French data protection regulator, issued a press release in which they said that they believed Google transfers using Google Analytics to the US would be unlawful. They actually updated that press release on the 18th of February, but they left the press release date at the 10th of February. But so just in case anyone has a look at it and gets confused and wonders where their sort of later update is of the 18th of February, it just got put into that press release. So after that, there's also been a decision published. It's an order to comply from the CNIL against a website regarding Google Analytics, and we don't know who the website is because they made it anonymous. But effectively, as far as the CNIL is concerned, transfers of personal data using Google Analytics will be non-compliant with GDPR. We also saw that the Dutch regulator pass comment. So we've heard from the Dutch regulator that they're actually looking at 2 investigations right now. So we're waiting for decisions on that. In the meanwhile, what the Dutch regulator also did is they went back to their guidance that they published a couple of years ago, which is on their website, around the use of Google Analytics. And they slapped a big warning notice on the top of it saying it may no longer be permitted to use Google Analytics. So they're just giving everyone a bit of a heads up. So it looks like the Netherlands may well be going the same way as France and Austria. Then we also had an opinion from Norway. So the Norwegian data protection regulator have said that they're considering a case as well. And it's looking like they may well go the same way as the other regulators. So this is what the Norwegian regulator said. They said, we know that there will also be more decisions about Google Analytics from other European data protection authorities. That's why we now recommend everyone to explore alternatives to Google Analytics. So that's quite a strong steer there. From the Danish regulator, they haven't actually got any cases, but they've just come out with supportive comments for the other data protection regulators, which indicate they're going to stand shoulder to shoulder with the other regulators and their opinions. From Liechtenstein, in Liechtenstein, they have indicated that they've had a number of complaints, and they've suggested that those complaints could be amicably resolved simply by deactivating Google Analytics. So again, it's a pretty strong steer from Liechtenstein regarding Google Analytics. And then in Guernsey, we haven't seen any cases actually there, but they themselves have stopped using Google Analytics on their own website and published an announcement which says, it's a reminder to us all that data protection is not a static box-ticking exercise. So it's an avalanche starting really across Europe, which was started by Max Schrems and his 101 complaints. Now, a lot of organizations use Google Analytics, probably the majority of websites use it. And what do you do in practice? Do you completely stop using it? You know, how big of a risk is it? Can you continue using it? Well, in practice, what we're seeing is a lot of organizations are continuing to use it because there's so many organizations that do, and are waiting to see what happens and what Google does as well. And and in the meanwhile, trying to do things which minimize the risk in terms of data transfers. So how do you go about still using Google Analytics, but applying some practical ways to reduce risk? Well, first off, so this is all about the transfer mechanism that was used and looking at the standard contractual clauses and the supplemental measures. So there is a possibility that you could use an alternative transfer mechanism. So under the GDPR, there are mechanisms called derogations. And one of those derogations is, for example, that you could use consent of the data subject to transfer personal data. So that is an option that some organizations are looking at. Consent comes with its own problematic issues. For example, people can withdraw consent at any time. So it might not be the most favorable, but it is an alternative whilst we're sort of waiting to see what's going on. The other practical point is to make sure that you turn on IP anonymization. So in the Austrian decision, the NetDoctor case, they actually had not configured Google Analytics to switch on IP anonymization. And although it wouldn't have completely got them around all of the issues, it would have been helpful if IP anonymization was switched on, because it would have reduced the amount of personal data being transferred. And in fact, Google Analytics, we've seen announcements from them that their latest generation of Google Analytics, number 4, will not be collecting IP addresses at all. The other thing that you can do is turn off data sharing. So with data sharing, this is a setting where you're sharing your analytics data with Google. So that could be switched off so that that data is not being shared. You can also switch off signals. So signals is a functionality which Google allow you to use, whereby they can enrich your data with data that they have, which is collected from people that have their ads personalization settings switched on. But you can switch off signals so that your data is not being enriched and you're sort of reducing the personal data processing that's going on. You can also make sure that you set things up so you're not sharing your own IDs with about individuals with Google. And the other thing that is certainly worth doing is carrying out your own transfer impact assessment. So under the European Data Protection Board guidelines on supplemental measures that you need to look at, over and above the standard contractual clauses themselves, this is one of the things that you are required to do. So you would carry out your own transfer impact assessment, looking at the laws and looking at the supplemental measures that are involved in the transfer. And Google may well have their own transfer impact assessment, which you might want to look at as well to help you with yours. So lots of practical things that you can be doing to reduce risk, although at the moment we're not in a position to completely avoid risk. If we move on to the next slide, please, Leonie. So you might also have heard that there's been some good news recently about what's being called the transatlantic data privacy framework. So this is basically the next generation of Privacy Shield, because actually, certainly in terms of Google Analytics and transfers to the US, if Privacy Shield is in place, that could make life a lot easier. Sorry, the Privacy Shield new version. Now, so where are we on this? So we've seen some announcements saying that really good progress has been made and agreements in principle are now in place. But actually, there's still some work to be done behind the scenes. And from what we've heard at Field Fisher on the grapevine, we're probably not looking until agreement being reached until the end of this year. So it's still quite a way off. And once that's in place, you'd then be in a position that you still need to get yourselves into that scheme. And ultimately, we know that there may well be a Schrems or others like Schrems waiting in the wings to challenge this new mechanism as well. So even if you did, Google went for this new framework, or you went for the new framework, there's still also the possibility that this could be challenged and come tumbling down like the others have in the past. You would hope that actually they're going to try and shore up the new framework so that doesn't happen, but there's no guarantees that it won't. So all in all, it will be good when it is in place, but ultimately it's not going to necessarily be a quick and easy solution for the Google Analytics transfers. Thank you, Leonie, and back over to you.
Thanks very much, Kirsten. I wanted to round up really by just saying a few words in relation to the trends we're seeing towards the use of first-party IDs, and really just to talk a little bit about the persistent data protection challenges, even in this context. So what do we mean, firstly, by a first-party ID? Essentially, what we're talking about is something that's an ID essentially that's owned and controlled by a publisher, so a publisher of a website or a mobile app, etc., as the case may be. And in that circumstance, generally speaking, the publisher is uniquely placed to get any necessary consents for the use of the first-party ID and related data, and to provide appropriate privacy notices. However, the term first-party ID is also being used as a term to describe a technology that is essentially designed to circumvent third-party cookie blocking in browsers. So what it means is that cookies are being placed through the domain of the publisher rather than the downstream ad tech intermediary or vendor. So if we look at what's happening on this slide, we can see, for example, user 123 going to an online newspaper. The related IP address is ending 475. The same user, but called something different, is visiting the website of a fashion retailer. Again, the same associated IP address ending 475. And then thirdly, visiting a tickets website known as a different user, but with the same IP address. So essentially, the downstream vendor or intermediary is then matching the hashed IP addresses or carries out some kind of device fingerprinting to probabilistically identify that these three separate first-party IDs actually relate to the same user. So there's basically matching of IDs going on, and it can, as I said, be done in different ways through fingerprinting or IP matching or in some other way. In some cases, the first-party IDs may, for example, even be based on deterministic data like hashed email addresses, for example. But ultimately, this is a technical solution to avert third-party cookie blocking. So essentially, it's a third-party ID solution that's essentially labeled as a first-party ID. And with that in mind, the challenges from a data protection perspective, are in fact the same. So the key points to note are that, e-privacy rules will be engaged to the extent that there is any accessing of information on a device or any storing of information on a device. So even though these use cases may on the face of them look like quote unquote cookieless solutions, they may well involve the use of cookies within the legal definition of this concept, because the legal definition of the concept talks about accessing information on a device or storing information on a device. And in many situations, you'll find that there's probably a tag being executed in the user's browser that generally causes the publisher to collect the data from the user's device. So, whatever device information that it's gathering in order to facilitate fingerprinting potentially by the AdTech intermediary. But regardless of whether the e-privacy rules are engaged, in any event, personal data is clearly being processed in order to uniquely identify an individual and to distinguish between that individual and other individuals for the purposes of targeted advertising. So, effectively the same challenges remain. Consent will be needed to the extent that there is use of cookies, assuming that the narrow, cookie exemptions don't apply. And also consent is likely to be the appropriate legal basis for the collection and disclosure of the personal data to downstream vendors for targeted advertising purposes. So even if cookies are not involved, regulators are likely to perceive that the processing is sufficiently intrusive to trigger a consent requirement, particularly in view of the fact that there is matching taking place from multiple sources. Furthermore, any downstream disclosure to vendors in the manner that I've just described on the previous slide would likely be considered a controller to controller transfer, because the downstream vendor is essentially likely to be engaged in processing of data for its own purposes, use of an ID on a cross client basis, for example, or other use of that ID. It's the third party ID, which is essentially being labeled as a first party ID for its own purposes. Given that there's likely to be a controller to controller transfer, that would mean effectively that in order to obtain a valid consent, the downstream vendor would need to be identified for the purposes of obtaining that consent. So it goes back to some of the challenges that were outlined by Camille, particularly where you have a multiplicity of vendors and you need to specifically identify those vendors for consent purposes. And in general, the relevant consent would need to meet all of the requirements of the GDPR. So while these technologies are becoming more prevalent, and while on the face of them they may look like cookieless solutions, or they may avoid the use of third-party cookies insofar as they avoid the technical blocking in browsers of the relevant cookie, there still is challenges to be overcome in terms of e-privacy and data protection rules. And we just thought we'd round up really by a brief consideration of what the future holds for online advertising. And it's worth saying that behavioral targeted advertising is very much in the sights of regulators, and they have been very active in commenting in this space in recent times. So we had commentary from the European Data Protection Supervisor, for example, on the 14th of March, whereby he made clear that it's time to make change happen. It is time to set clear limits to online targeted advertising. The ICO issued an opinion in November 2021. The opinion related to data protection and privacy expectations for online advertising proposals. And in that opinion, again, it made clear that new initiatives must address the risks that AdTech poses and take account of data protection requirements from the outset. But it even in stronger terms, the opinion made clear that any proposal that has the effect of maintaining or replicating existing tracking practice, such as those described in the 2019 report, is not an acceptable response to the significant data protection risks that the Commissioner has already described. So really marking the card of the various players in the AdTech ecosystem that this area will continue to be a matter of regulatory scrutiny for some time to come. So I think that's probably a good place to wrap up. I think we've had a couple of questions, so let's have a look at those questions. We've got one. Firstly, looks like it's one for Camille. Camille, the question is, does this decision reflect, and I think it's referring to the Belgian DPA decision, reflect the views of other DPAs, or is it representing the view only of the Belgian DPA?
Thanks, Leonie. So this decision, or the Belgian DPA in coming to this decision, it was part of the one-stop shop process. So they consulted other EEA DPAs, the other EEA DPAs. They submitted a draft decision to them. And so they all had a chance to give their sort of opinion on the decision. And I think IAB Europe or the Belgian DPA, one or the other, reported that I think that initially there were 2 objections to some parts of the decision, but then the final decision was approved by, I believe, all the EEA DPAs, data protection authorities, under that one-stop shop process, which is, in that process, for anyone not familiar with it, sort of enables EEA DPAs to all be, for there to be a lead authority in certain circumstances. So I think, that suggests that it does reflect the views of other DPAs. But saying that, I think it's going to be very important to see what the outcome of the appeal is, because, that appeal is going on, and the decision in a way is not really final until we have that outcome.
Great, thanks, Camille. Yeah, we've quite a number of other questions coming in. There's a question in relation to Article 49 derogations that you mentioned, Kirsty, and specifically the derogation relating to consent as an option. And the question is whether that, they're intended to be used only on a one-off basis rather than for regular use. And if I can comment, and then I'll hand over to you. I think that's absolutely the case, that it is intended that would be not for systematic and regular transfers, that it would be only on a sort of a case by case, one-off case basis. And certainly the regulators have commented to that effect in the past. But I think, and I'll let Kirsten comment now, that what we're saying here is that one option is to use it as a backup, while also maybe having another mechanism in place, but having it as a potentially additional option, purely as a risk-based approach in the meantime. But Kirsten, you might want to comment further on that.
Yeah, I think that's right. And I think so historically, in the old data protection legislation, we had these sorts of derogations, and it's always been the case really that these sorts of derogations were intended to be used sparingly, so not for mass data transfers, but it's the occasional transfer. I think when you look at the derogations itself in the new GDPR legislation, it actually says that you can use consent, but you have to inform people about the possible risks of the transfer due to the absence of the adequacy decision. So there's actually quite a bit of information that you ought to be providing along with the consent, and that's in line with sort of making sure that consent is an absolutely transparent, explicit consent, and people understand what it is they're consenting to. So it's not ideal from that perspective. And then also in the recitals to the GDPR, where they say that actually, yeah, you can use this derogation if you have explicit consent where the transfer is occasional and necessary in relation to a contract or a legal claim, or regardless of whether in a judicial procedure, etc. So actually, but when you look at the recitals, it could be seen as being a little bit unclear as to whether they mean that it's only the transfer in relation to a contract or a legal claim that should be occasional or necessary. But if you're erring on the side of caution, then I think I would take the view that the consent-based reliance should be occasional as well.
Great, thanks, Kirsten. I think another one for you, Camille, and this may have to be the last one because we've just 2 minutes to go. We will follow up with the other questions. And as the question as to whether the session is recorded, the answer is yes. So the question we have, Camille, is: do you think data protection authorities will start taking enforcement action against TCF participants?
So I think first it's important to note that the decision was against IAB Europe rather than TCF participants. And also, we've got this appeal ongoing, and it would seem strange to me for other data protection authorities to start to initiate enforcement on the basis of findings made in a decision that's currently under appeal. So I think, the hope for TCF participants is that, enforcement won't be taken at this time, and that the other DPAs will wait and see what happens with the appeal. I think one of the other data protection authorities, I think it was the Dutch Data Protection Authority, was reported in a newspaper to have refused to confirm that they wouldn't take enforcement action. But as I say, I think it would be strange if action was taken at this point, and I think hopefully they'll wait and see, or hopefully for the TCF participants, they'll wait and see what the outcome of the appeal is.
Great, thank you very much. And that brings us to the end of today's session. So thank you very much for your attention, everybody. As I mentioned at the beginning, the slides will be sent out to everyone who's registered, and we will follow up with the additional questions. So thanks all.